Good morning, everybody, and welcome to the 4th annual Scary Stories presented by the McBrayer Employment Law Department. This year, we titled it Little Shot of Horrors. Our marketing department has a great time, a lot of fun with the titles of these. So we welcome you, glad to see you back, and are excited to be able to present on not just COVID topics. Obviously, it's been a scary 18 months with COVID, and we've talked endlessly about it. We just conducted a webinar 2-3 weeks ago. We're going to touch on a few COVID issues just to bring you up to date on a couple of things, but mostly we want to get back to the business, why we're all here, which is employment law. We want to focus on traditional employment law issues, as well as those things that are trending and things that you should be thinking about for the start of 2022. So the first thing, like I said, we're going to start off with is just an update on some of the COVID issues. We have talked about this before, but we want to just bring you up to date. I think everybody has heard that back in September, President Biden issued an executive order, not only related to federal contractors, but also to employers of 100 or more individuals, that there will be a vaccine mandate for those employers. It also includes healthcare organizations that receive Medicare or Medicaid funds. You on your own, if you're not falling in one of these categories, may also decide to do a mandatory vaccine policy. And if so, we want to give you a few guidelines moving into this. One thing we don't know yet is the executive order as it pertains to those with 100 or more employees. If it's going to be a mandatory vaccine policy, or that you either have to be tested or receive the vaccine. We're still waiting on that. We wish we had an update, but we don't as of this time. So you should be preparing for one or the other. So here we go. In our traditional format, we're going to start off with the first scary story, that you are an employer of 100 or more employees, and you implement a mandatory vaccine policy pursuant to the executive order. And you've got individuals who are requesting a religious exemption. How do you handle these requests, and are you required to give the exemption? So we are trying to make this a little more interactive, and we're going to give you about 10 or 20 seconds to answer this poll question. Am I required to give an employee a religious exemption to the vaccine mandate? If you can click, if you want to participate, click on those. We'll give you a few seconds.
Oh, I should have brought my glasses.
All right. So we'll end the poll. We've got a lot of yeses, a few maybes, and a couple of nos. So let's move to the answer. And the answer is, Brian, if you can. Oh, hold on just a second. Thank you, Brian. Yes-ish. So the Title VII of the Civil Rights Act and the Kentucky Civil Rights Act requires, under the religious discrimination provisions, to allow religious accommodations for beliefs and practices. And you guys may have been dealing with those with respect to work on Saturdays, particular dress code issues, and other various types of religious accommodations. The vaccine mandate is no different than those. And for those of you who work in healthcare or who put children through public school, you've always had the opportunity to seek a religious accommodation for a vaccine mandate. The other accommodation would be under the Americans with Disabilities Act. If an individual has a medical condition that would prevent them from getting the vaccine, you would engage in that interactive process and determine whether the accommodation would be given. Both of these exemptions, and we're just going to talk about the religious exemption because it is one that is really common right now, and I'm going to go into a few of the common requests that we have been seeing. But both of these have an ability for you to not only accept the accommodation as something that would qualify, but deny it as a result of undue hardship. And under the Americans with Disability Act, you would have to show some, for lack of a better term, some significant financial hardship. But under the Title VII or the Civil Rights Acts, all you have to show is some minimal invasion, some minimal obstruction. And what does that mean? That could mean that it is costly. That's always an option. That it compromises the safety of employees, decreases efficiency, infringes on the rights of others, requires other employees to pick up the slack of those who are receiving the accommodation and do their more than their fair share. So all of those can be considered in getting a religious accommodation request, which someone says, I have a sincerely held religious belief that prevents me from getting the vaccine. If it causes an undue hardship as one of those under those factors, you can deny it without questioning the sincerity of their belief. If you are going to deny it, you should also take into account a few factors, and those factors have been identified by the EEOC. Those include whether the individual works indoors or outdoors, if they're working with a group, if they're working closely with other individuals and have contact with others, the type of workspace that's involved, the nature of the duties, whether they're dealing with people who are vulnerable, who might not be vaccinated, for example, the number of vaccinated individuals within your organization, because that could also impact. If you have 1 out of 100, then the accommodation may not be an undue hardship. The amount of traffic that your organization has. Here at our law firm, we have clients coming in and out, but that's very different from the Home Depot, who have customers coming in and out at a far greater, bigger pace. And then the number of accommodation requests you're getting. If half your workforce is requesting an accommodation, then that's going to also impact whether or not you can show an undue hardship. So the best advice we have is to understand what the factors are when you're dealing with an undue hardship, and understand how you're going to apply those, and certainly apply those consistently. So a couple of things that we want to point out. When you get a religious accommodation request, you have to assume that the belief is sincerely held. Religion is very broadly defined. And unless you have objective evidence to suggest otherwise, you have to assume that it's sincerely held. So we're seeing in the common categories of religious accommodation requests are claims that fetal stem cells were used in the vaccine development or production, and I am opposed to abortion and I don't want to contribute to it. That is something that if you want to deny the accommodation on this regard, under this, you can talk about the fact that if the individual is receives or uses other medications that were also used, or that also use the fetal stem cells in their development or production, and those include Advil, Tylenol, aspirin, Sudafed, and 15 or 20 more. If the individual receives a prescription from their physician, do they do the research to determine whether that particular prescription was developed or tested with the use of fetal stem cells? You can ask an employee to verify and certify those that they do not use and will not use those particular medications. And you can certainly ask them to also certify that they will do the research if they receive a prescription medication. That sometimes will identify that this particular individual doesn't have a religious belief about abortion in general. It won't take away the abortion in general objection, but if they're selectively applying it to this vaccine, then it's more of a personal objection to this vaccine than a religious objection. The other one that we're seeing commonly is my body is my temple, and that is from scripture, and I don't put anything in my body that would, we're seeing things, change my body's natural immunities. Well, if as an adult they also receive vaccines, or if they use other medications, that's certainly something we can talk about in the interactive process to determine whether this particular religious belief applies to them as a whole or whether it applies just to this vaccine. And if it's just to this vaccine, then the sincerity of the religious belief can be called into question and denied. And finally, we're seeing a lot of, I'm a Christian, I don't do this. It's very generic. We'll see quotes from the Bible. And while they may believe in those quotes, and we're not calling into question that, unless the employee is able to state that how my religious beliefs affect the ability to take the vaccine, the request can be denied. So the last part about this is that those beliefs can't be social beliefs or political beliefs or personal beliefs. They have to be religious beliefs. And so your interactive process is going to be, depending on how you want to approach and address these, your interactive process is going to be fairly robust. Here's something that, we have seen or we're going to see with regard to the personal beliefs versus religious beliefs. In Vermont in 2016, it removed from a statute non-religious personal beliefs. And suddenly 3.7% of all incoming kindergartners had requested religious accommodations from their vaccine mandate to come into the public school system. Before that was removed, the religious accommodation requests were at 5% or 0.5%, which suggests that they're more personal beliefs than religious. And if so, that's a ground for denying it. And so it just tells us that we can engage in the interactive process and we can look behind it. And your philosophy as an employer and how you're going to apply these accommodation requests will be completely up to you, but you really do need to be consistent in how you apply them. If you're going to request that individuals certify that they're not going to, take Advil or Tylenol if their objection is based upon the fetal stem cell development, then you're going to have to apply that to everyone, not just the ones that you believe are cherry picking. I would recommend that if you have a vaccine mandate, you try to get all the accommodation requests in at about the same time so that you can review them and apply them consistently and create your parameters and your rules for it. And lastly, what I'll end with is even if you grant an accommodation, that doesn't mean that it ends there. You can continue to require an unvaccinated individual who has an accommodation from the vaccine mandate to wear a mask, get weekly testing. You can restrict them from social events. You can restrict them from coming in the office without a test or things like that. You may also have to move their job position if you have positions available in other departments, depending on the nature of what they do and the risks associated with keeping an unvaccinated individual in that particular department. So with that, we're going to be done with COVID and we are going to move on. And I'm going to switch over to Claire.
Would you mind? Yeah, perfect. Okay, so this next section is called the discriminator. Brian has so much fun with this and I love it. Okay, so our next scary story, an employee at your workplace has been making derogatory comments about a transgender coworker and is refusing to use the coworker's correct pronouns. You bring the commenter in to talk to HR, but they insist you can't discipline them because they're exercising the First Amendment rights. Love that that's in there. And besides, they say sexual orientation and gender identity aren't protected classes. Are they right? First things first. Every labor lawyer hates this First Amendment right argument because, and I know this is off topic, but I feel compelled to address this. As an employee for a private employer, you have no First Amendment rights. You only have First Amendment rights if your employer is a government agency, like state, federal government agency. So this is true whether the comment is verbal or electronic. So if your private employer tells you to take that Facebook posting down, you should listen because you do not have First Amendment rights to post whatever you want on Facebook, even though it is not work related. So that's just an aside. I know in a lot of social media, there's been a lot of screaming about First Amendment rights with private employers, and it just frustrates me. Okay, so that's my first rant. Second, no, they are not right. Sexual orientation and transgender status are considered protected classifications under the term sex. So what does that mean to us? Okay, so here's the next question, and it's a poll question. Can you require an employee to use another employee's preferred pronouns? And feel free to answer this, but while you're answering it, I'm going to explain. For those who haven't encountered this yet in their workplace, we're referring to alternatives to the standard he or she. So he denoting a male, she denoting a female. For queer or non-gender conforming, non-binary, transgender people, these pronouns don't always fit. And those individuals might ask you to use an alternative pronoun. So if you haven't been exposed to it, it would be they, them, Z, it sounds like C, or her, HIR. So an example would be Tyler ate her food because Z was hungry. Or they might ask you to use a pronoun that more accurately fits their gender identity, but doesn't conform to your perception of the gender. So an individual who is born as a female or a she, and now self-identifies as he. So that's what we're talking about right now. Okay, so our poll results are in. We have 46% who said yes, 35 who said no, and 19 who said maybe. So it's pretty much split. Okay, so the answer to that question is, oh, I can't. Yeah, it's okay. Sorry about that.
Oh, you have to click the side. Yeah, there you go.
Yeah. Okay, so the answer is, in fact, yes. Okay, so you do have to use the individual's preferred pronouns, and we're going to talk about that for a minute. By the way, as a side note, if you're ever in this situation, never use the term it or he/she, so he, she. That is considered a slur, so you just kind of want to avoid it when dealing with gender nonconforming folks. Okay, so why is this true for question 2? Oh, hang on. Well, I'm not there yet. From a purely non-legal perspective, why is this a yes? Well, think about how an employee feels being called the wrong sex. It would be uncomfortable if you saw yourself as a man through and through, but your boss kept referring to you as she or he. Okay. So now we have another poll. If you have a transgender employee, is it discrimination if you don't use that employee's preferred pronoun? Yes, no, or maybe? Okay, so we have 78% say yes. Oh, it's kind of shifting. 4% say no, and 19% say maybe?
Yes.
Okay, all right. She's helping me because I'm blind. All right, so the answer again is yes. Oh, and my numbers are off. Okay, so it's okay. So going back to our example, if you corrected a boss and explained that you were male, but your boss kept referring to you as female, how would that make you feel? Disrespected, not worthy of consideration or thought, right? Or think of it another way. Let's say my boss keeps referring to me as Cindy, and I say, listen, my name is Claire. And he says, oh, yeah, Cindy, right? And every time I meet him, they call me Cindy. Okay, so from a non-legal perspective, you don't feel seen. You don't feel that they respect you. And that would be embarrassing. So in the same regard, we have Bostock versus Clayton. So Bostock was fired after he mentioned being interested in the gay softball league. Lower courts went with precedent that Title VII does not apply discrimination on the basis of sexual orientation or gender identity. The Supreme Court ruled that it is protected. Right? No, thank God.
Yeah, I was just fancy for you.
Sorry about that.
No.
Oh, wait, one back. Sorry. So what does that mean? What are the practical applications of this, of pronouns and gender identity? You can't always know what somebody's preferred pronouns are just by looking at them, right? But now we're told, okay, but we have to pay attention to folks' preferred pronouns. How do we do that in the workplace? Well, depending on your workplace, you could consider listing your pronouns on your signature page as a way of inviting other people to do that. I see that all over. Nonprofits have really jumped on that bandwagon. You could ask for an individual's pronouns when you meet them. I find this a little uncomfortable and weird, but it is a practice that some people use. Or you could just use their name until you learn their pronouns. This is what I try to do because it feels more socially comfortable. So what if you make a mistake? You don't want to be the guy who refuses to use pronouns and now has a lawsuit against them. If you make a mistake, just calmly apologize, correct yourself, and move on. If you make a mistake in front of a group, maybe you don't want to apologize in front of the group, which would draw up more attention and cause more embarrassment. Pull the individual aside and say, listen, I know you said that your pronouns are she, and I just forgot, and I'm going to try harder. And that's really all you need to do. And know that this is not easy, that this whole situation of getting used to folks' pronouns and understanding that somebody might need or require a they, them versus a he, she, is sometimes hard and we trip over it. But the more we're exposed to this, the easier it will get. And really what you just need to do is try to be respectful of other folks, and then you'll be in the clear.
All right, back to me. And before we move on to the next topic, I just want to add as an aside, the transgender and the gender identity issues that the U.S. Supreme Court has opened with the Bostock case are new to all of us, are new to many of us. And it is something that we all, including Claire and me, we have to educate ourselves, and we have to attend webinars, and we have to attend seminars, and we have to do our best to learn how to advise you as employers. And in 2022, we do believe it will be an emerging issue for the EEOC, and we will be conducting seminars on that topic because it's something that there's a lot to learn. I actually just learned recently, or just through Claire's presentation, that there's a pronoun Z, and there's a lot to learn. And what we don't want is for any of our clients to be the next case that is an example that is used in webinars. So we're just going to ask that you, as we will be educating ourselves over the course of the next few months. So, and it's something that we've got to just get a handle on and understand. So the next topic that we want to shift to is pay equity. Because we've had a few cases in the news recently about it. It is something that with COVID has been brought to the forefront, because when everybody was sent home and when schools were sent home, by and large, women bore that responsibility for a number of reasons. And they took on the schooling and the household duties while also working from home. We've seen the memes, we've seen the videos, we've seen the TikToks. It is undoubtedly something that has been brought back into the forefront as a result of the pandemic. But so let's have a little reminder before we switch to the next slide. Let's have a reminder of what the pay equity issues are. In 2021, Forbes magazine published a study that 86% of women earn 86 cents of every dollar that a man earns. That has not changed much over the past decade or two. We're closing the gap somewhat, but it is still not there. There are a lot of reasons behind it. You've got the glass ceiling, where there are obstacles in the way for women to advance in an organization and make more money. And those could include having childcare responsibilities, for example, that they have these dual roles. Something that I also want to educate people on is something called the sticky floor. We have the glass ceiling and the sticky floor, and those are disadvantages that women face as a result of assumptions that they are less qualified for the job. There are a lot of other examples. There are subtle biases. There are not so subtle biases. There are
Oh, sorry.
Sorry, we accidentally muted. What employers need to do is they need to be reviewing your pay practices to determine if you have pay discrepancies. And if you do, what are the objective reasons for those? Some of them could be education and experience, but if you can only come up with subjective reasons, you might have an issue. So let's talk about pay equity. Let's talk about our scary story in pay equity. We've got rumors in the office that women and minorities aren't making as much as their male or non-minority counterparts. They're swirling, you get nervous because your pay practices must come under scrutiny. What are your responsibilities under the law? Initially, I must first state that if you have an employee handbook provision, and Claire's going to talk about handbooks in a minute, but that prevents, or if you have a policy that prevents individuals from discussing their pay, it is a violation of the National Labor Relations Act, and you cannot do that. So make sure that you're not doing that. So let's start with our poll question. Anybody who'd like to participate, we certainly invite. I can pay employees anything I want. That's between me and the employees, and I'm under no obligation to equalize those pay for different genders. Is that true or false? All right, responses are still coming in, but the overwhelming majority of you are falling into the false category. We've got 80% false, 20% true. And by this, this is an interesting poll question. Obviously, the answer is false. So let's talk about when you can and can't pay men and women differently. The Equal Pay Act from 1963 does prohibit wage discrimination. It is based on statistics alone. It doesn't mean that you look at someone and say, well, you're a woman, I'm going to pay you less. Okay, that doesn't come into play. We're talking about equal pay for equal work. And what does that mean? That means you have similar skill, effort, responsibilities, and conditions of employment. It also could require similar supervisors as well. We often see this in the medical field. You often see Equal Pay Act cases where you have a female physician and a male physician who graduated at about the same time. They're performing the same duties, seeing the same types of cases, and the female physician gets paid less. And even though there's no, hey, you're a woman, I'm going to pay you less, there's no commentary that would fall under harassment, such as, comments about moms or women in the workplace. It is simply statistical. And so it has a different structure than a discrimination claim. And so what we need to do is recognize that if you have individuals who are performing a similar job, similar title, similar duties, if they're men and women or minorities for that matter, you have to look to make sure you're paying them equally. And there really is no better example than the recent example of the U.S. women's national soccer team. By now, I think everybody has heard of the lawsuit that the women's soccer team has initiated claiming less pay than men. Now let's talk about this. They're playing the same game on the same size field under similar conditions. The women, however, performed far better and got paid far less. So the statistics are actually outstanding. Initially, people might think, oh, women's soccer probably doesn't bring in the amount of revenue that men's soccer does. Yeah, they've won a few more, but the men's competition is far more strenuous. Well, let's look at it. The statistics on the U.S. women's national team versus the men's, the women have won 4 World Cups in 8 tournament appearances. The men have won 0 in far more tournament appearances. The women have won 4 gold Olympic medals. The men have won 0. Between 2016 and 2018, the women brought in $900,000 more than the men's organization. And in 2018, total, they had a $2 million surplus, where the men in 2018 have a $3.5 million deficit in their budgets. In 2014 and 15, we had the men and women went to their respective World Cups, and the women's team won and the men's team lost. Carly Lloyd, who actually just retired yesterday, was one of the top 3 goal scorers in U.S. women's national team history. She has an outstanding record. She was paid after the 2015 win. Her salary was $240,000. Dempsey, who was playing into the 2014 World Cup and lost, was earning $428,000. And they actually lost in the round of 16, which was super early and super embarrassing overall. And so again, here's an example. You can't dispute that they're playing the same game under the same conditions. The numbers are there, the statistics are there, and probably in lines with some of the no answers we had in our poll question, the U.S. National Soccer Organization said, well, we struck a different deal with the women. They just agreed to different terms. And so it wasn't discrimination. We had a contract. They agreed to it. Why can't we engage in those arm's length negotiations? Well, when you have equal work under similar conditions, if you're not paying equal pay, it can be called into question under the Equal Pay Act. So what should employers do? First and foremost, this, like the transgender issues, will be an emerging topic under the EEOC guidelines. It is something that, like I said, through COVID, it has brought to light a lot of equal pay issues. But last year, maybe it was this year, the U.S. House of Representatives passed the Paycheck Fairness Act. And it is an attempt, it's not gone through the Senate yet, but it is an attempt to strengthen the Equal Pay Act and to try to fast track an equalization of men's and women's pay. What this statute, if passed, will require is that if you have a disparity in pay, you're going to have to show that it's job related and consistent with a business reason. And so you're going to have to find objective reasons for the disparity in pay. You are also going to be prohibited from asking salary history as a result of in a job interview. Because it has been shown statistically that women have been paid less. When we interview candidates, you say, well, what were you making, so that you know how you can beat that, how you can lure the candidate. Well, if the pay has always been substantially less for women, it's an artificial indicator, and they will continue to be paid less because you're starting at a lower level. So as a result, what I think should be happening just in terms of your equal pay issues is you should already be implementing these. Even if this Paycheck Fairness Act doesn't get implemented, you as an employer should be considering, your audit and make sure that any disparity is objectively based and is job related, and that you're not asking salary history. Ask in terms of what do you need, what do you want, versus what were you making, so that you know where to start. And so those are the types of things that you should be considering when you're talking about what should my organization should be looking at in 2022. In addition to some of the other things we're talking about today, it's going to be equal pay, and gender identity issues should be on the top of your education list. And so with that, we're going to switch to another scary story for Claire, and we're going to talk about employee handbooks and what sort of changes you should be identifying in your 2022 handbooks.
And hi again. And this doesn't just deal with handbooks. I think it was just easier to put it under this, guys, but just remember, this deals with any kind of policy, any kind of contract. So if you have an employment contract, you're going to want to pay attention if you have any kind of severance agreement. So any agreement between the employee and the employer needs to be viewed with this lens. And so let's get started. Okay, so the scary story is an employee complains that your policy on non-disparagement of the company on social media is affecting their rights, and they threaten to make a complaint. What you thought was a straightforward policy has given you no trouble, but now all of a sudden people are starting to act like it's worrisome. What is wrong with asking an employee just to be respectful? Oh, I don't know why we're not advancing.
Try the arrow. Oh, there we go.
No. Okay, so the next question is, I have a policy in my employee handbook that says employees aren't allowed to publicly disparage my company. Is that lawful? You guys are jumping all over the place.
I love it.
I know, me too. Okay. Some of you are changing your answers midstream. Let's see. Okay, so we're about evenly split. It started off one way, but now we're about evenly split. It says 53% to 47%, 53% say that it's true, you can have a policy. What you guys don't realize is that you are reflecting the actual law, because it is going back and forth and back and forth and back and forth, just like you guys just did. Okay, so, and just to explain this, I will tell you that there was an advice memo from 2019 dealing with an employment agreement, and this was the non-disparagement. During and after an employee's employment or association with law firm ends, for any reason, employee will not in any way criticize, ridicule, disparage, libel, or slander a law firm, its owners, partners, or law firm employees. And they had a rider that says, however, nothing in this section shall be deemed to limit or prohibit an employee from engaging in group activity under the National Labor Relations Act, 2019. This was held to be unlawful. And they said it impinged on an employee's protected concerted activities. And what the employee did was she criticized the employer with a negative review on Glassdoor, Indeed, AVVO, Yelp, and Yahoo Business. Really got all the social media sites. And so that termination was reversed. So this is how important it can be to follow the law on this one. Now, 2020, just 1 year later, you have Baylor Medical Center And in a severance provision, it says employee agrees that she shall not make, repeat, or publish any false or disparaging, negative, or derogatory remarks, or otherwise take any action which might reasonably be enacted or expected to change or damage the employer. And that was held lawful. So we have 1 year, everything kind of changed and it was thrown up in the air. Why is this? Well, the reason it happens this way is because the National Labor Relations Act, although law, is interpreted by the National Labor Relations Board. And those folks, along with the general counsel, who is there to prosecute claims, changes with each administration. And so the law changes with each administration. Okay. So Section 7, for those who haven't been to the NLRB webinars we hold, provides that employees can engage in protected concerted activity for the improvement of their working conditions. So what does this mean? Concerted means multiple employees, right? Or one person working on behalf of other folks. So if I say, hey, Brian, I don't really like my wages and Cindy's are crap too. Well, now I'm working on behalf of her as well. Talking to one or more coworkers to induce action. So if I say, hey, Cindy, your wages are crap and my wages are crap, let's do something about it. Even if you say no, even if Cindy says no, jump off a bridge, that's now concerted activity, right? So what's in that pot? All of the things that relate to wages, hours, or working conditions. So all the things in your employee handbook and your severance agreement, all of that stuff is collected in this National Labor Relations Act, Section 7. Now, protections can be lost. And a lot of what we're talking about in terms of disparagement is, are these protections lost? And one of the things that you can do is if the employee who is engaging in lawful action does something super offensive, egregiously offensive, or says things that they know are maliciously false, or disparage your employer's products or services, you will lose protection of the act. But that's kind of squishy. What does that mean? Well, again, it changes with each administration, and how we define it and how we describe how we can lose those protections changes. All right. So just for a bit of a background, there's been two competing standards. Lutheran Heritage was the standard when I first started practicing. The employee could reasonably construe a policy as interfering with their Section 7 rights. So if I look at a policy and it says, do not disparage your employer, and I say, well, I kind of feel like that means that I can't go online and say my supervisor is a jerk because he yells all the time and he makes us all, feel intimidated and crazy. And I'm talking about it with all of my coworkers online. I feel like that's interfering with my ability to do that. Under Lutheran Heritage, that's protected concerted activity. But then Boeing came along under the Trump administration and says, no, that's too loosey-goosey. There are all these rules that interfere with Section 7, but we need to actually look at it under a different lens. It's not a reasonably construed policy. And so they created these three categories. The first category is always legal. The last category is always illegal. And the middle is kind of in the middle. So that's what we were dealing with under Trump. Now, usually it takes a long time for the NLRB to change, but President Biden made it clear that it will not take very long under his administration. He, the first day, fired the old general counsel and assigned a new general counsel as interim. This is really fast acting. Usually people don't really pay attention to the National Labor Relations Act very much until Biden. So as a result, these policy standards are shifting back in favor of employees pretty quickly. So the employer justification standard from Boeing is likely to change back to the Lutheran Heritage standard, which is going to be applied way more broadly. Okay, so what does this mean for you guys? Shifts in the handbook standards, shift in severance agreements, shift in employment agreements are all going to affect you for all of those documents. Now, you probably already have all of those documents in play right now. And I understand that you don't want to have to evaluate each and every one of them. That's okay, because right now we don't know what it's going to look like. We don't know if we're going to bring back Lutheran heritage. We don't know how far the pendulum is going to swing, but it's really good to pay attention to those contracts going forward and those policy changes going forward to anticipate that that pendulum will swing. Review your policies, review your agreements until the change is officially made. You're good. But contact your attorney and start talking about those things now. And a labor lawyer. Contact a labor lawyer. Okay.
All right, so our final section is going to deal with sexual harassment because we can't have an HR seminar without a discussion of sexual harassment.
Yeah.
And while we have a scary story to discuss here, we are actually going to end on a positive note. Oh, I just popped out the batteries. We're actually going to, I got it. We're going to end on a positive note for employers with a Kentucky Supreme Court case. So let's first look at the scary story, and then we're going to go to the not so scary story. And this is going to lead to a poll question, I believe. Is that right? Yes. All right. You write a disciplinary action for one of your female employees, only to find out that one of her colleagues has had engaged in conduct that ranged from making sexual conducts to burying her head in her bosom. And she sues you claiming sexual harassment and discrimination. So just how bad do you think this is going to get? We've got some, some comment or some conduct that we traditionally see in sexual harassment cases. So the poll question is conduct of a sexual nature, any conduct of a sexual nature, enough to show that a hostile work environment exists? This is our last poll question. All right, we are looking, as we're getting the responses in, we're looking at about 50-50. And that is pretty much what we expected. And here's why. The answer is actually, hold on. The answer is actually false, because the standard is a hostile work environment. It has to be severe or pervasive enough to alter the terms and conditions of employment. But what our employees believe, and what a lot of people believe, is that if you make a lewd comment or sexual advance or pass around a dirty joke, that's enough. And you hear employees complain, and while it's inappropriate under the law, it may not be enough. So here is the not so scary story. And it's a Kentucky Supreme Court case from last year called White versus Commonwealth, where we had a female law enforcement officer who made some complaints similar to the one in our poll question, that there were sexually explicit images. One time a man buried his head in her chest. There were jokes going back and forth. But what's not in this slide, but I will tell you, is that it was infrequent. It happened on an occasional basis. There was evidence that everybody, including the plaintiff, used some rough language. In one instance, she actually sends a picture to one of her coworkers of her dog's testicles as a joke of some sort, that she also laughed at some of these jokes. And so subjectively, she was engaging in similar conduct. And a hostile work environment requires both objective criteria, objectively offensive and subjectively offensive. She also complains that she was written up, that she was given less desirable work duties, and she was retaliated against for complaining, and ultimately she quit. And so this is a case that has 2 points for employers. One is, what really is a hostile work environment? And 2, what sort of liability do you have when someone quits? Well, a constructive discharge claim requires that the conditions be so intolerable that the person is compelled to resign. And in Kentucky, that is a very, very high bar. The allegations, as mentioned in her case, did not rise to that level. And then the other aspect of it was, what is a hostile work environment? When does it exist? And so I told you generally a shortened version of the definition that it's severe or pervasive to alter the terms and conditions of employment, and that it's objectively and subjectively offensive. What do we look at? A hostile work environment does not exist if the language is merely offensive. You say, Cindy, what does that mean? What that means is if people are engaging in boorish or adolescent type of conversation and commentary, that is probably merely offensive and not severe or pervasive enough to alter terms and conditions of employment. If it's infrequent, if it happens on an occasional basis, while inappropriate, and we should always talk to our employees about not engaging in that type of conduct, because there is a snowball effect and it could lead to a hostile work environment. If it is infrequent, it is not a hostile work environment. And then the subjective standard, and this person is a good illustration of it, if the individual is also engaging in jokes, laughing at them, participating in them, sending her own pictures of inappropriate things, it is going to negate a hostile work environment. And so ultimately, our Kentucky Supreme Court said that obviously this isn't, the sexual remarks and everything that happens isn't going to be taken into a vacuum. You're not going to look at it in a vacuum. We're going to look at all of it. And so we need to remind our employees frequently in training what a hostile work environment is and what it isn't. While we are going to have a policy against these types of comments, and we are going to address it when it happens, and we're going to tell our employees, hey, cut it out. What we don't want is other employees to think, aha, he said something one or two times, and now I'm going to sue you. We need to balance that. We need to educate our workforce on what it is and what it isn't, and what our obligations are. And this Kentucky Supreme Court case is reassurance, because we always come in and, I mean, you've been to these seminars before, and we tell you some pretty outrageous cases, and we give some pretty outrageous facts. And people say, yeah, but that doesn't happen to us. Or if it does, wow, that's certainly bad. So I wanted to give you some good news. So those isolated incidents is what the court said in this case was not enough to rise to the level of a hostile work environment. The court also said that it wasn't the commentary, the nature of the statements were just merely offensive. So they didn't even meet the objectively offensive standard that it was set forth by the US Supreme Court decades ago. Also important was that the commentary and the discussions and everything going back and forth didn't unreasonably interfere with her ability to do her job. There was no distress. She was not calling in. She was not so affected by it that her performance had decreased. And so there was no evidence that there was any interference. You know, subjectively, she had a foul mouth. She participated in it. And interestingly, the court acknowledged that on the police force, there is a lot of rough language used. So your environment and the nature of what the group of people do and say can come into play, which I found to be very interesting in this Supreme Court case, because now we do have that some example, and we're going to have to be careful how we apply it, but some reasoning to say that if this is commonplace amongst the people that work together and they're all equally participating in it, that it is subjectively allowed, that maybe we now have another avenue to dismiss these cases. And so this is just an opportunity for us to remind you about those trainings and how important they are to educate your workforce, because it's one thing to have an open discussion, a candid discussion about inappropriate comments. And it's another thing to come in and say, I'm going to sue you, right? And what we want to do is diffuse the situation before it gets to the, I'm going to sue you, whether or not they still work for you. And so those are the types of things we need to have open discussions about. We need to, make sure we're telling our employees, cut it out when the language does get inappropriate. And we need to, just be on top of it, more or less. And the education piece for all of our topics today are things that I think are a good reminder as we start 2022, what we should, again, be focusing on. So again, a little less scary because that employer was successful, but the employer, it was the Commonwealth, but the employer still had to pay attorney fees and go through the whole process. And that's what we're trying to avoid, is you being pulled into a lawsuit where your time and expenses are being utilized to defend claims that should never have been brought in the first place. And so we have 10 more minutes, and I just want to touch on two things before we open it to questions. One, and this truly is a scary story, or it can be. Some of you may have remembered a couple of years ago, the Kentucky Court of Appeals decided a case or affirmed a decision from a trial court that prohibits employers from representing themselves before the Unemployment Commission as the unauthorized practice of law. And if that case is now before the Kentucky Supreme Court, if that case stands, all of you who have participated in unemployment hearings where we're telephonically on the phone with the hearing officer, and you've done that on your own and you've done it successfully, you will not be able to do it on your own. You will have to have a lawyer. We will keep you updated. Our blog will, as soon as the decision comes out, our blogs and our new newsletters will send out alerts, but it is something we should all be keeping an eye on. It's Nichols versus Kentucky Unemployment Insurance Commission. We're hoping for a decision soon because the state that right now it's at an influx, is in a state of flux, and no one knows what to do with that. And lastly, for those of you, I know we said we wouldn't talk about COVID too much, but I feel like we could end it on this note. For those of you who extended the paid sick leave and the extended family leave under the Families First Coronavirus Response Act, that ended back on September 30th, 2021. We have not seen an extension of that, and I don't believe it will be extended. So just for those of you who were unaware, it has expired, and you no longer have to provide that paid sick leave. And if you do voluntarily, that is fine, but you will not get a tax credit for it. So as always, we appreciate you joining us for our 4th annual Scary Stories. We always enjoy Brian's humor and I guess the pictures that he puts up. We are here for you whenever you need us. Our contact information is there, and we will be happy to answer any questions. You can contact us after this as well. Has the final OSHA mandate been signed? No, it has not. I haven't even seen a draft of it. Have you?
No, it went up to the White House. I think it was a week and a half ago, 2 weeks ago. It has not been publicized. I don't think anybody's seen a copy of it. They do think it's going to mirror the federal mandate or mandate for federal employees. But I mean, at this point, we're just guessing. So, you know, we have to hold tight. I do think it will come out in the next week. So we'll have more information soon.
And the time frame to comply, we obviously don't know that, but because the only FDA approved vaccine is in 2 doses. And then to be fully vaccinated, you need 2 weeks after that. We're looking at somewhere between 4 and 6 weeks. And I can't imagine that the mandate would say you have to comply in less than that time period.
Right.
We will furnish the slides after the webinar. And then another question, taking request employees to take down Facebook posts. What about, oh, Brian, can you scroll down?
Oh, yeah.
Oh, yeah.
Okay.
All right. If you're asking an employee to take down a Facebook post, is there an NLRB protection? So generally speaking, as long as it doesn't touch on NLRA concerns, you can ask them to take it down. As long as it doesn't, isn't a concerted effort to engage in protected activity about terms and conditions of employment, you absolutely can ask employees to take down Facebook posts that affect your business. And we've actually dealt with that over this past year. I know, Claire, you've dealt with one. And it's certainly, I'll turn it over to Claire to continue to comment on that.
Yeah. So if you have if somebody posted something on Facebook about their,
Wages, hours, and working conditions and said, me and my, coworkers believe X, Y, and Z, there are 2 separate issues. So one, can you ask them to take it down? Yes, because they are engaging in that behavior. But you can ask them to take it down. You just can't discipline them for it if it engages in, if it talks about wages, hours, and working conditions. Now you can say, listen, if it has anything to do with the employer's product, the employer's service. So in other words, X company gives terrible customer service and their products are junk. Okay, then you can take adverse employment action. But if they're just discussing the way a supervisor engages in disciplinary action or writes them up or has favoritism or any of those things, I think the best way of handling it is to take that information and talk to those employees, because now you have intel you didn't have before and you can solve the problem before a union can come in and try to solve it for you.
All right, I think that's all the questions. We appreciate your time and we're getting you out of here right before lunch. So enjoy the rest of your day and happy Halloween.
All right, and this is Brian Powers. I'm the marketing director, and I have to put in a note as well real quick for everybody that we had a lot of questions. Yes, we are going to send out an email to all registrants early next week. That's going to have the slides in it. It's going to have a link to watch this again on the video. Feel free to share that with whomever you want. We also at some point would like to have a return to our in-person employment law seminar. We're aiming for that this coming year. So please keep checking back, follow our blog and follow us at McBrayerfirm.com. For all your employment needs, please don't hesitate to give us a call. Thank you.